At the end of your medical malpractice trial, after the judge has explained the law to the jury, if the jury does not understand any of the judge's legal instructions, is there a limit to how many times they can ask the judge to repeat it or to re-explain it over and over and over again? You want to know the answer? Come join me for a moment as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. The doctor whom you sued laughs at you and says, "What are you doing? Why did you sue me? I did nothing wrong here. And if I did something wrong, so did you, Mr. Patient." And then he says, "If I did something wrong, whatever I did didn't cause or contribute to your injuries." And then he says, "You know what? If I did something wrong and I did cause you harm, your harm really is not that bad." Those are the typical defenses we see in these medical malpractice cases. So now the doctor denies everything about your case, which means your case is going to go the distance, which means you're going to go through the litigation process. And in New York, for a malpractice case, that can take anywhere from 2 to 3 years from the start of your case until the time you finish your trial. So now, you finally get all the way to trial. Let's say your trial takes 2 entire weeks of hard-fought litigation. All the evidence, all the testimony, all the witnesses are in. And now the attorneys have made their closing arguments. And it is time now for the judge to charge the jury. Now what does that mean? It means the judge is going to give the jury the law as it applies in this particular case. The judge does not participate in deciding who is right or who is wrong. That is the entire function of the jury. The jury decides credibility. The jury decides whether you are slightly more likely right than wrong, that what you are claiming is true, not the judge. The judge will tell you that you are the fact finders, that you have to decide what the facts are in this case and then apply the law as the judge gives it to you. Okay, so now the judge spends at least an hour, 45 minutes to an hour, explaining the law to the jury during his charge. After the attorneys have finished giving their closing arguments, the judge actually tells the court officer to go and lock the courtroom door. Now that's not to prevent anybody inside the courtroom from getting out. Rather, it's to prevent anyone outside from getting in to disrupt the jury's attention. The judge wants the jury to pay extreme attention to what it is he has to say, because their verdict is going to be based on the law as the judge describes it. So during the entire time that the judge is explaining different parts of the law to the jury, there are some concepts that are actually difficult to understand. So now the jury is told what they have to do. They're told they have to answer a series of questions in a very specific order. And once they reach their decision about each of those questions, then they are to report back to the court officer, who then notifies the judge that they have a verdict. Okay, but during the course of jury deliberations, once the jury goes back to their jury room to go ahead and start deliberating, if they don't understand something about the law, can they actually raise their hand or send a note out to the judge that says, "Judge, I'm sorry, I didn't understand the definition of medical malpractice. Could you tell it to us again? Could you explain it to us again?" And the answer is, yes, he can, and yes, he will. The judge wants to make sure that the jury does understand what he's told them. Now, the judge is going to discuss those issues with the attorneys, and he's going to tell them exactly how he's going to handle it, how he's going to answer or re-explain a certain issue that they were having a problem with. All right. Then he brings the jury back into the courtroom, and now he'll say, "Ladies and gentlemen, I understand you're having some difficulty. You would like me to re-explain the definition of medical malpractice." And then he'll go ahead and launch into an explanation, and he may even give examples or use an analogy to help the jury understand. And then he'll tell them, "All right, go back now and start deliberating again." And now they will do that. But what happens if they still don't understand the definition? Can they come back out, or can they write another note to the judge? Say, "Judge, I'm sorry, we just still don't understand it." In that instance, will the judge re-explain it? The answer most likely is yes, he will. So there really is no definable limit about the number of times that jurors or the entire jury can come back to the judge and say, "Judge, I'm sorry, we still didn't get it. Could you explain it to us a different way? Could you explain this one a different way?" And yes, the judge will take the time to go ahead and explain it. But there may come a point where the judge says, "Listen, I've told you now a number of times the definition. I've used multiple explanations. You go back now and figure it out." That actually could occur. But in all likelihood, after 1 or 2 or maybe even 3 times, the jury will finally get it, because the judge will have made it easy to understand. He'll make it simple to understand using different examples, and hopefully that will solve the problem that they were having. So why do I share this quick information with you? I share it with you because this does come up often where the jury has questions and now they want something explained again, or something was not clear in the judge's instructions, and now the judge has to address it and will try and explain as best he can what the answer to their question is. You know, I do realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking about doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.